Let's see, we should have 10, and we have 2, 4, 6, 8. We are missing Joe, and we are missing who else?
Oh, no, we're missing Caitlin, but she's not here this week.
That's right. Yes, I knew that.
Because she is,
Mhm.
she's Disneyland. She might be having more or less fun depending. And Joe Alexander.
And just for the record, is it Macbeth or Macbeth?
Beth. Think of,
You
think
got
of
an ex-
Shakespeare.
Well, I do think of Shakespeare quite
Well,
often.
exactly. Just forget about the A.
I will.
Words like Arthur Jackson. First potato pan famine was in Scotland, so we moved to Ireland and I changed the spelling to.
Do you know that today is the perfect date? I call to order this special committee on the Family Division of Circuit Court. And I've got an opening statement which I hope will set the tone. I've had much of this with different individuals, but now this is for the record. The immediate cause of this special committee is the experience at the beginning of the 2023-2024 term of the House Children and Family Law Committee. Several bills with which we were presented addressed perceived errors on the part of the Family Division of Circuit Court in the state of New Hampshire. Subsequent testimony by bill sponsors and by the general public alleged, among other things, failure to follow or enforce statutes, unwarranted waiver of or failure to follow court rules, delay in rendering decisions, denial of due process, and other procedural issues. This is consistent with comments I've been hearing for the past decade. Testimony from representatives of the judicial branch deny these things were taking place. So whom do we believe? How can we put a lot of these allegations to rest? What do we do going forward? As chairman of that Children and Family Law Committee, I arranged for a meeting with the Honorable Gordon MacDonald, Chief Justice of the Supreme Court, the Honorable David King, Administrative Judge of the Circuit Court, and others. We arranged for the first of what we hope will be a series of continuing education days for both the House Children and Family Law Committee and the House Judiciary Committee. However, we came to believe more was needed, hence the constituting of this special committee. It consists of 10 members chosen equally among the two political parties represented in the House and equally among the Children and Family Law Committee and the Judiciary Committee. It was my privilege to do the voir dire. Those considered for membership were individuals who were deemed to be impartial. That is, they were not known to be of strong opinions about family court one way or the other. They had not recently served as lawyers representing anyone in cases before family court. They had not recently been a judge. We wanted people who could be neutral in hearing what was presented to us. Testimony will be collated by the two committee secretaries appointed, one of whom is away this week. And the collation will be primarily on the basis of topics. That's a little different from the minutes of most committee hearings. We will want the filing of information to be by the topics comprising the various complaints against family court. For example, if we in the next several weeks get 12 specific bits of testimony about violation of the rules of evidence. All of those will go in that rules of evidence complaint file. Testimony from the various stakeholder groups and from individuals from the public will be collated. For that reason, in order for one's testimony to be helpful, as the special committee eventually draws conclusions on the way to making recommendations to the judiciary, and as we consider possible new laws, testimony must be specific. Specific first in terms of signing the pink card so you may testify. You have every right to give just your name. However, if when we consider your testimony, we have some questions for you, some follow-ups, when a couple of weeks, a couple of months from now, we look at your testimony and we want some clarification, you will do your case well if you put on the pink card your contact information, phone and email. Once again, you do not have to do it. But if you've come to testify because you want to convince us of something, that will help as we follow up. Second, in terms of specifics, is the testimony that we will allow. Generalized statements are not helpful. Oh, everybody knows the courts are biased against dads in a custody hearing. I don't know that, and that's not helpful. That's a broad assertion. It is not fact. To say the judge didn't follow the rules of evidence proves nothing. However, if in your testimony you tell us specifics on what day was the trial held, at what time, before what judge, in what courtroom, and at what point was evidence proffered that was refused. Now we have something to go on. We may go back and try to look at the trial record to get a context. Anything short of specifics like that will not help your case and will waste everyone's time. So prove your case. And if others do the same on a particular issue or another issue, we may have something to go on in terms of reform. Next, please understand, those of you who would come to testify, we will not retry your case. So do not come and give us a story about how your case was mangled in the court. Now, in colonial days, the legislature often received petitions for the redress of grievances. According to former House Legal Counsel, the Honorable Charles G. Douglas III, this was because, and I quote a memo to me, there were few standing committees in the legislature. There were few bureaucratic agencies in the executive branch to deal directly with the grievances of individuals or groups of citizens. So much of the legislation that was introduced was enacted in response to petitions. In other words, the court, the legislature, was pretty much the court, the executive department. It was almost all three branches of government minus a royal king. That retrying of cases, however, stopped. In the September term of 1818, the Supreme Court of New Hampshire, in the case of Merrill v. Sherborne, wrote this: an act of the legislature awarding a new trial in an action which has been decided in a court of law is an exercise of judicial power. It is also in its operation retrospective for these two reasons. It is unconstitutional. At the end of the opinion, Merrill v. Sherborne, and I believe members of this committee have been provided with a copy, and of Councillor Douglas's statement, the legislature cannot pass an act, and our judgment, therefore, is that the proceedings of this case, which was the request to retry a case, is quashed. So therefore, Any testimony that appears to ask the special committee to challenge a court verdict will be interrupted and not allowed to continue. In terms of witnesses, stakeholder groups, because they represent many individuals, will be given some considerable time in making their presentation. But they too may not make broad generalizations, but rather must cite specific instances with date, approximate time in the hearing, the name of the judge presiding, and the perceived error that was made. Again, prove your case. Members of the public will be given 5 minutes, and this will be timed. House Rule 100 allows this to happen. We hope that there will be a 4-minute, 30-second polite warning noise to let you know you get 30 seconds to wrap up, with a less polite noise at 5 minutes when you're done. You'll be allowed to finish your statement, and then your microphone will be turned off. Now, we do this for a couple of reasons. Number one, there probably, as we get going, will be numbers of people who wish to testify. And if we just let individuals testify until they run out of air, we may be going on forever. Secondly, to make an allegation of a perceived error doesn't take that long. It does not take that long to tell us the date, the place, the time, where in the trial, who is the judge, and the perception of error. Or if there was no error, that the rule that was followed should be changed. That won't take long. So this will help people be on point. Those of you who wish to testify, please fill out a pink card. Hand it to the nearest member of the committee. Don't walk it up to me, but hand it to the nearest member of the committee, who will then pass it along. Now, if you filled out a pink card and it's come in, and you've heard the testimonies and realize what you've written out won't be accepted, you can have another bite of the apple. If I call your name, just say, Mr. Chairman, I would like to revise my testimony. May I testify at another time? The answer is yes, you may. Because we want your input to be as helpful to your case as it can be. If you have written testimony to hand in, please make sure it is that kind of testimony. I, for one, will not read through volumes of stuff that talk about this one is corrupt and that judge's cousin is such. I don't read those things. So don't waste my paper, please, or yours. Boil it down to what we need to hear. There are 10 of us, and there's a clerk's file, so if you wish to turn in things, 11 copies would be helpful. And because we have much to do, we will adjourn at 12 noon. If somebody is testifying at 12 noon, that person will be allowed to continue, but will be the last person to testify for that day. Believe me, some of us around the table have been here to 9 o'clock at night because there was only one day set aside for a committee hearing. Any pink cards that are left over at noon that have not been utilized, I haven't called on you, will go to the head of the list for subsequent weeks. We are presently scheduled for May 2nd, 9, 16, and 23 at 9:30 in the morning. We will take off May 30th, which is the day after Memorial Day. I have asked the committee to reserve in their calendar the first 3 Tuesdays of June. We may or may not need them. We'll find out. So if you did not get called upon to testify and the noon hour comes, I will start with you and others from that leftover batch the next week, unless you can't be here, and then give me a date and I'll put your name and date in that. Before we break for the summer, the committee may decide to make some preliminary suggestions to the judiciary. This will be discussed, and we may make those suggestions. We may not. We will call upon the judiciary later on this spring to make comments. For example, let's suppose we are going to be opening up that file on rules of evidence. We would like the judiciary then to come and give us specifically printed copy and testimony what those rules of evidence are. I have discovered that there are numbers of people who know about rules of evidence because they've watched 22 years of Law and Order on TV, to which I will say, despite my great respect for Counselor Jack McCoy, those are criminal cases. We're talking about civil. The rules are different. So we will hear from the judiciary, not so much as a rebuttal at this point, but to outline the specifics of those issues that seem to be presented to us. I believe when our work is finished, a few of us will draft a final report, which will be reviewed by the entire special committee for revision, and we hope eventually final approval. Individual members may decide to craft some draft legislation for the next year. I conclude with reading the notice and disclaimer. This was printed on the back page of the last House calendar, and I have been asked to read this statement at this and every committee meeting because we want to make very sure that if you're coming here, you will speak in ways that we will hear. So here goes. The Special Committee on the Family Division of the Circuit Court was formed to investigate allegations of irregularities, including failure to follow or enforce statutes, unwarranted waiver of or failure to follow court rules, delay in rendering decisions, denial of due process, and other procedural issues. The committee will conduct hearings relative to the process of the Family Division of the Circuit Court and may make recommendations for future legislation. The purpose of the committee is to discover areas where changes in procedures or changes in law regarding the Family Division of the Circuit Court may be made. The purpose of this special committee is not to retry the cases of citizens who disagree with the outcome of litigation. Members of the public will be given an opportunity to testify and present information to the committee. Because of the number of people who may wish to testify, there may be a time limit imposed on each person testifying, which is permissible under House Rule 100. Appropriate subject matter for testifying will be limited to specific instances of where there seemed to be irregularities in process, procedure, or adherence to rules and statutes. Those testifying about subject matter related to a court case or who submit documentation relating to a court case should know that both will be made part of the public record. Therefore, subject matter that is either confidential or may be under seal should not be discussed or submitted to the committee, as disclosure of such matters would be a violation of statute or a court order. And let me parenthetically add, the burden of this will be on those who testify. It may not be immediately apparent to any of us in the committee or to me as the chairman. Something that is said shouldn't have been said. I may not know that, so you're going to have to be very careful about this. Finally, the committee reserves the right to not accept written or oral testimony or materials which would, in its judgment, violate the foregoing. So, with that as the long introductory statement, anybody wish to respond from the committee? And I call upon my vice chair.
Thank you, Mr. Chair. I was honored when the speaker asked if I would agree to serve as vice chair of this committee. I am honored because the speaker asked me. I am honored to be able to serve with the distinguished chair of Children and Family. I have my normal home is with the Judiciary Committee, and I have had a long experience with the Judiciary Committee and am ranking member. I follow closely the decisions that are made by my fellow legislators who serve on other committees when those decisions seem to involve the workings of the judicial branch, since in fact it's the Judiciary Committee charged with oversight of the judicial branch. It was of great concern to me when I discovered, now I guess it's at least a month ago, perhaps more, that a bill had passed children and family law, overwhelmingly supported by the members of children and family law, that expressed concern about the operation of the family division of the circuit court, and expressed that concern so strongly that, among other things, they asked that the committee, Children and Family Law, be given subpoena power to subpoena the judges of this state. I must say that that shocked me. And it was that shock that caused me to go to speak with Speaker Packard about my concern. And I believe that I was not alone. And I know that the chair sitting on my left was immediately involved and receptive to concern expressed about that bill. And for that, I thank him. I have listened for the first time to what the chair has just said, and was interested in much of what he said, and concerned because it did sound to me as if it were a trial rather than a legislative hearing, in which the legislative hearing in which we would be collecting information as much as we could from disparate sources to make sure that we in the legislature do our part in how the three branches of government work, but recognizing that there are three branches, and, for example, recognizing that it is not the legislature, but the judiciary that makes the rules for the operation of the judicial branch. If we were to move to change those rules, I think we would quickly find ourselves before the courts, which seems a little something that's full of irony. I look forward to working with this committee, with members from both the Children and Family Services, Children and Family Law Committee that has one perspective and one line of experience, and members of the Judiciary Committee that have another set of experiences and knowledge, because I think together we could create a very rich and deep understanding of the complexities that we face in society today and that are reflected in the incredible challenges faced by the family division. We might find that the family division is suffering because of lack of resources. And that is something that falls specifically within the venue of the legislative branch in terms of creating positions and in terms of financing. And that's a perfectly appropriate thing for us to do. I also think that we can serve a very important function in giving people an opportunity to articulate their concerns and know that somebody is listening to those concerns as long as they are presented in a way that the chair so thoroughly discussed, not to retry a case, but to see where there might be what could be called a pattern or practice that gets in the way of the family court doing what we would hope the family court would do. So I come here without prejudging. I come here with the same feelings that any one of us might have as citizens about, yeah, I like that decision, or no, I don't like that decision, but without believing that there are institutional factors about those decisions. And I know that I am convinced that at the end of this practice, under the leadership of the chair, this committee will calmly, intelligently, thoughtfully, and in a very balanced way identify ways that we in the legislature can do a better job legislating, and therefore hoping that that will help the judiciary doing a better job adjudicating. So I thank you for listening, and I am looking forward to hearing what others say.
Thank you, Madam Vice Chair. In terms of the bill that passed, I believe unanimously, it was House Resolution 14, and it looked good in a lot of ways, but we were informed that a couple of items of it were in violation of either House rules or something else. And at that point, and I believe, Madam Vice Chair, you were very much conversing with the Speaker as well. I said that the request of a committee that House Resolution 14 spoke of is something I'd like to go forward. And so collectively, that's why we're here, is the real gist, the real meat of House Resolution 14. Here we are. Anyone else on the committee? Yes, the chair, Councillor
Thank you, Mr. Chair.
Macbeth.
So I appreciated your comments. I'm honored to be appointed to this committee. I did want to just point out, since, and we can talk about this later, but I think in your opening remarks, you said that, anyway, I am a practicing attorney in the family division, and I am a certified guardian ad litem in the family division. It's only about 20%, maybe 30% now of my practice, but just based on the comments that you had made, I had been vetted with my leadership, and you and I had talked, and I didn't see that being a practicing member would disqualify me, but if it does, perhaps we can talk about that
You
later.
passed my voir dire, Councillor.
Okay. All right. Okay. Thank you.
Yes, this may embarrass you, but then again, you are a lawyer, so maybe it won't. But I did ask you some push questions to try to see if, in my opinion, you could be a disinterested party, and you passed with flying colors.
Thank you very much.
You're welcome.
I'll do my best.
Anyone else as we begin? Wow. I'm expecting a tsunami of pink cards starting next week. I have no pink cards here. Nobody has come indicating you wish to testify. I hope I didn't scare you off, but I do hope, okay, would you fill out a pink card? And remember the kind of testimony that will be helpful to do what we are doing. Meanwhile, Counselor, you may be interested. I'm reading several equivalents of Introductory to Law for Idiots. I'm really plugging through it. I've watched 22 years of Law and Order, knowing the differences, and I'm really trying to get up to speed on this. And no, I'm not going to law school, but I did pass a practice LSAT exam.
Maybe you could pass those books on to me, and I could see if I could learn a few things.
Okay. The chair recognizes Paula, is it Wormy? Vermy?
Worma.
Wormy. And I'll start my watch. You got 5 minutes, and just remember the parameters in which you may testify.
Okay, yes, sir. I witnessed a terrible injustice in the family court. In a case where the court didn't even have subject matter jurisdiction, 3 separate judges basically stripped a protective parent of custody, and then they proceeded to scare her straight out of the state and handed custody to the abusive ex. Then they basically ransacked her half of the marital estate and gave it to the husband. As a result of this terrible injustice, I decided I was going to do an audit on the courts. I basically sold my home, built out a van to live in, and drove up here last fall, and I'm here again, still auditing the courts. I wish to be recognized as an expert to testify for the length of time as Mr. Head. I know what's going on. I know the reasons.
Have already raised an issue of 3 judges stripping a parent of custody. You have not provided name, date, time, place, specifics. It is not information for us. You got to hit it again.
I'm sorry. I will bring the information. This is the organizational meeting.
Yes, it is.
I'm just telling you that I understand statutory reasons for what is going on is wrong. I understand constitutional reasons. I understand the reasons the judges are violating the rules. I understand that in general, and I've looked at probably 150 to 200 of these cases, they don't issue scheduling orders, and that's why some of these cases are carrying on for 15 years. They never schedule something for trial. I can bring you specific instances when it's time to bring in testimony.
When it's time to bring in testimony, yes, please do. The rules I've articulated will be in place.
Okay, but my point here today is I need more than 5 minutes. I would like as much time as you give to the judicial branch.
I will give you 5 minutes, and I may call upon you to come back again, but I will not give you a recognition as an expert witness or blanket amount of time. You will have to prove yourself. If you prove yourself in the first presentation you make, you may be called upon again.
Okay, thank you.
You're welcome. Seeing no further pink cards, I would like to introduce to us, I heard some bad news the other day that Attorney Head, who had been the consultant, I believe, to both of our committees, at least I meet him over there by the law books a lot, is moving on to another position. And would you come on up, please, and introduce yourself and tell us a few things about yourself as the new link.
Us here. I was the House Legal Counsel before the year 2000.
Well, you move the microphone closer. There weren't microphones then.
No,
We could hear them too.
my name is Lori Platt, and I've worked for
Could you spell that, please?
Lori, Lorrie, Platt, Platt.
Lori Platt. Thank you.
I did work for the House up until the year 2000, at which time I left to work at the Supreme Court, where I've remained ever since. And I've been asked to provide whatever information and research I can for this committee. And I don't know what else to tell you. I do have some background in the family division, in that my youngest child came to our family when he was 8. So I've been through in order to adopt him, he was in the foster care system. So I have some experience with that. I don't know what else to tell you. Before I was with the House, I was with the Attorney General's office.
What position do you hold with the Supreme Court?
I'm the reporter of decisions.
And would you explain, I know what that is because you taught me what that is, but would you explain in case anyone else doesn't know?
I think my sort of primary responsibility there is to oversee the issuance of opinions and orders, but I do a lot of research for the court and drafting, and I at the current time I'm the secretary for the advisory committee on rules, but I will be giving that position to Tim Gudis, our clerk, the clerk of the court, so that I can better serve this committee.
Will you be replacing Attorney Head as the liaison to our committees? Not this committee, but the ones we come from.
I don't know how that's going to work. I've only been asked to staff this particular committee.
Okay.
I take my guidance from Diane Martin and the Chief Justice.
If we're nice to you, maybe you'll do it.
Up until very recently, I was working many more than 40 hours a week. So I have been trying to, with their support, curtail my work. But to the extent that I can help anybody, that really is something I'd like to do.
For going forward, and you can certainly, if you haven't already, begin the research. It's the several specific charges that are made against family court. The judges all seem to lean over backwards to favor the ones who are pro se, or the judges don't like people who are pro se. Well, those are obviously two different charges, or rules of evidence aren't being followed, or scheduling protocols aren't being, where there is an allegation that seems to be coming from several people, what are the rules? What are the protocols? Why is the delay? Is it fair or unfair that something is put out 3 years? Someone who has complained to us saying, why every time I go to court, the opposite one brings in 5 more petitions? Why does the judge hear that and not just say, enough, we're done? Those kinds of questions about procedures. I know, for example, what my vice chair articulated, the reason sometimes things are taking time is there's not enough judges, and I think we got 7 more coming for circuit court if this budget keeps that in and is signed into law. So there are answers to some of the questions. Those would be good topics to start the research on. And as you listen to testimony here, you'll start to hear trends too. And certainly you can talk with the clerks of the committee, and they can say, oh, we've got 6 things in the folder marked such and such. That would be good to start formulating some answers.
Okay.
Okay.
For what it's worth, as I understand that the judicial branch at some point will come over, and the judges would, I think, some of them would come and answer some of your questions also. I don't know when you want to do that, but
As I'm working on scheduling of stakeholder groups, we've got different stakeholder groups which are enumerated in the memo establishing this committee. And I've asked my committee researcher who is doing the scheduling to not bring the judiciary over early in the process. We want to hear from as many people as can do it
I see.
rightly, their information, their complaints. Only then can the judiciary come and explain. I am heartened, and this does not prejudice my ultimate decision, but I am heartened already to hear both from Administrative Judge King and from the Chief Justice that any helpful suggestions are welcome. So this will help us. Anybody else? You have a judge in the family. You don't have any questions? Okay, okay, good. Well, Representative Long.
Thank you, Mr. Chairman. Yeah, serving on Children and Family for 8 years, 9 years. there's been allegations of inconsistency. So, helping to know how the judicial checks themselves may be helpful. I know that sticks out in my mind that, I mean, we're hearing, Judge X decided this way. My friend's the same case as mine, and Judge W decided this way. Why is, I don't think they like me. And the same with judicial review, inconsistencies with that also. So just a heads up on what the chairman also stated that we hear.
It would be helpful at some point for you or someone from judiciary to explain to us to the degree it should be. In other words, no betrayals of confidence, obviously. How your, and I keep blanking out the name, it's the group, the committee that investigates the possibility that a judge has gone bad.
The Judicial Conduct Committee?
That's the room, to know how that works.
Okay.
I mean, if you can wing it now, fine. If not, come back.
I'd prefer not to wait.
Yeah. Because obviously, there's private information and should be private. And having been privy in my day work line of work to serving as a judge on one of those things, I do know the process of how it works and the confidentialities that are important, but it would perhaps be a relief to some members of the public to know that there is such a thing and how it works and what you look for. That would be very helpful, I think, for some folks. Representative Gregg.
Thank you, Mr. Chairman. You made me think of a question. And actually, then you started to ask a similar thing. So on one thing that we've heard multiple times that I don't really think I need more evidence of, but is people saying that recordings are being stopped. And I know that in other states on these kind of oversight committees and stuff, they have people that will go sit in random like courtrooms and stuff that are actually from the judicial branch to see if the recordings are being stopped, kind of like a guest teacher or something. Is there any kind of observation that we have in the judicial system that looks for stuff like that? Because there have been specific incidences we've seen of that kind of stuff. Either they think it's on record and supposedly the judge stopped the recording, and then we've heard that they can't stop that. So I'm really interested to hear more about kind of how that goes and if there's any observation or protocol for kind of regulating that kind of stuff. Thank you.
Underscoring that, anyone who is watching the video of this who believes this took place, because we did hear a few examples of that in Children Family Law Committee. We would like to know what day, what court, what time, so that we can review the tape or at least ask a court administrative officer what happened. Also, at some point, we would like to schedule a road trip to sit in on family court. It's probably going to be very difficult for us to all keep our mouths shut, but we'll try, and speak with someone afterwards, obviously not to review the case we just heard. But from that and other cases we may have witnessed, generalized questions. And then this occurred to me late at night when I was reading one of my intro to law books. What about moot court or mock court, depending on which term you like, where, I mean, we do this in the legislature for new legislators on how to not behave in the legislature when we're having a session. And, we'll have somebody cross in front of the speaker and, all of those things you're not supposed to do to show us what we're not supposed to do, not just by giving you a list of rules, but actually having a play. And so something like moot court or mock court that could bring out a typical family court case with actors, derived from a conflation of numbers of cases, so we're not retrying an exact case, but a generalized one with subtitles, running commentary. that would be worth the price of the admission, I think. If some point you could get some law students to do that for us.
Oh, I'm going to pursue that. That's an interesting idea. We have interns at the Supreme Court.
Uh-huh. And the chair now recognizes anybody from the committee who wishes to ask further questions of, you're an attorney, I'm going to believe, right?
Yes,
Okay, Councilor Platt, thank you for coming. Seeing none.
thank you.
Chair recognizes Representative Baruti. I'm sorry, I've totally blanked your name. Bernardi, I knew that. You're in an adjacent district to me.
Thank you. Representative J.D. Bernardi, Rockingham 36. So I was the sponsor of H.R. 14. I am not an aggrieved party in any family law condition. I became aware of issues in the family court system by campaigning. When I campaign, I knock on doors, I ask questions about my constituents or potential constituents. What is bothering you about issues in New Hampshire, whether it be taxation or whatever, Second Amendment, and it's issues that they raise. They raised with a reasonable frequency problems in the family law court, that were unique to them. So I became a sponsor of the legislation to essentially see if we can get to the bottom of what seemed to be a legitimate number of due process issues. And I say legitimate in that I just didn't take this on because I heard complaints. I actually met with these folks in meetings and we reviewed physical documents of here's the judge's decision, here's the cases, here's the problems that where there were seeming divergences from some sort of semblance of what I considered reasonable behavior. My opinion. But that was the genesis and the rationale for bringing forward H.R. 14. The need for subpoena power, well, you can argue one way or another. I thought it was necessary in order to get some answers when answers were not forthcoming. But if the judiciary is going to be responsive, then we'll get those answers. The issue that I have today is this is the first time there's been an opportunity for what I would call a charter or how this committee is going to operate and its expectations. We're just hearing it for the first time. The people that need to testify that have the specific experiences that you're asking for don't know this yet. So there needs to be some way to publish and get that information out to them that you are looking for X, Y, and Z. And please come to this committee and make that case. Now, I don't know if that is publishable in the calendar or some other place, but the testimony Child and Family law heard on various bills, there was a targeted bill that dealt with issue A, B, or C, and people came and testified on that. This seems to be, all right, the door's thrown open to potentially anything, but what things and what do you want? So you, Chairman Pearson, went over a selected list of criteria. I do think that needs to be fully published and made available so people know, and the dates that you're having hearings so they can potentially plan, take time off from work or whatever activities they may have and show up and actually present the information that they need to present so you can interrogate the issue further.
I have a press release ready to go, just waiting for this specific day, this committee meeting to end. I just wanted to hear a little bit more from my colleagues. I was intending to speak more specifically with some of them over the weekend, but it was the weekend from hell. But the press release is ready to go, which will do exactly that. Say when, where, give the rules of the road, and I do hope the newspapers publish it as I send it out, because it is designed to do exactly what you suggest. Secondly, I will ask my committee researcher, and it may be either you or my committee assistant, to go back to those retained bills in children and family law and find the pink cards and see those pink cards who came to testify as a aggrieved individual, if there's contact information so that they can be contacted and informed this thing is rolling. And then thirdly, Representative, you really did your homework, and those people who you sat down with who produced documents, call them, let them know. We are scheduled to meet the first 4 Tuesdays of May, 2, 9, 16, 23. Maybe the first 3 Tuesday mornings of June, but that way they'll know ahead of time.
So one additional question then, could you potentially publish your editorial or whatever in the calendar as listed? You know, normally we list a bill and what we're subject matter is being discussed. If that could also be in the calendar with the specificity that you went over, the kind of information you're looking for, so people who follow the legislature can look there and identify, yes, this is how it's going to work.
I will speak to the clerk of the House, what a notice is. I've already submitted the dates for May, and if I misspoke, it's not the 1st, 2nd, and 3rd of June. It's the 1st, 2nd, and 3rd Tuesdays of June. So it's a whole bunch of Tuesdays, but not the 30th of May. I will speak to the clerk. If you would speak to your constituents, we'll try to find the ones who testified. If there are similar bills about the judiciary that came to the Judiciary Committee, maybe you can ask for the pink cards to be researched, and press release will go out this afternoon. If you can think of any other way to get the word out there, let me know.
Just in the calendar. That's it. Thank you.
Okay. And thank you. And it was only on 2 very minor points, but were deemed to be disqualifiers that the HR 14 resolution was tabled. Everything else, as you know, sailed out of here. We didn't know until later there were a couple of disqualifiers. So here we are. Here's the committee HR 14, I hope, wanted.
Thank you.
Thank you, sir. Chair recognizes Mr. Dana Albrecht.
Is this on? Good morning, Mr. Chair. Forgive me, I wasn't prepared to speak today.
If
so-
you're not in conformity with the House rules, I'll give you your pink card back.
But I just wanted to address what I heard from Ms. Platt.
Okay?
I think a little clarity on who is doing what over at the judicial branch right now might be very helpful. Given
That's
that
fair.
I wrote an email to Mr. Head yesterday concerning whether an audio recording was supposed to be 10 or 20 minutes. I could give you date, time, docket number. I had sort of planned on discussing that offline with him, but just a little more clarity on what's going on and who we can bring these issues to at this time would be helpful. If you'd like the diamond docket number, that I can give it to you. Otherwise, that's all I have to say.
When it's time to make your presentation, after you've done any consulting And I do appreciate your doing that. We get a lot of people coming through here who have not done their homework. Thank you for trying to do yours.
Yeah, it's an issue of who do I do it with at the judicial branch. Thank you.
Okay. I don't know the house rules over there, but perhaps counsel can let him know if this is admissible, and if so, who he speaks with. So maybe you could have a little, ex parte afterwards.
Perfect.
You're welcome. Thank you. And the chair recognizes Joseph J. Is it Nugent? Okay, I think it was the last time I read your card. Then it wasn't. You have similar handwriting.
Thank you. My name is Joseph Nugent. I live in Effingham. I wanted to just start. This is the first time I've ever testified here in Concord,
Okay.
but I am very grateful for the process of this special committee beginning. I know that today is just an introductory day. I did have a question whether or not people might be able to testify more than one time before the committee in their 5 minutes, because unfortunately I have a family case that's become very complex, and I'm not sure that the issues could fairly be addressed in only one 5-minute presentation. But
Well,
today-
why don't we try you for one, and if you do conform to the ways of we're receiving testimony, what we'll do is hear from others, and then we'll, if you did a good job the first time, we'll give you a second, maybe a third bite of the apple.
Good, and I'm hoping that that doesn't become necessary. Unfortunately, I think that some of the issues might be. So preliminarily today, I didn't want to miss an opportunity to have the microphone where we had time before noon. I did have concerns about due process and irregularities in my family case. And I just believe that in general, this is an important check and balance from what I found from enduring the family court here in New Hampshire. That without a check and balance that's instrumental in our government, problems occur. And specifically, in my case, I'm very concerned about an RSA regarding access to 911 calls. So there's a rule in New Hampshire that's affected my family case and my relationship with my now almost 11-year-old child, where the situation where my son had been taken from me was recorded by E911. However, the legislature here has passed a rule that doesn't allow for the issuance of that 911 call without a judge's signature. Now, I've made this request in many motions before the family court and before our Supreme Court during my appeal process. Even our Supreme Court has denied me the 911 call. Now, I've had evidence, which when I have more chance to prepare, I will provide evidence to this committee that shows that the situation was a 10-minute phone call. This is done on a time and dated stamped piece of computer paper ticker that comes out at the county office where the 911 calls go through. And during the resulting criminal process of my case, where I was charged with domestic violence, I was charged with even hitting my son, which was thrown out of court. This 911 call is evidence, but I was only provided during the criminal discovery process for 6 minutes and 7 seconds of this call. It was altered because it was not provided to me. So the issue that I'd like to bring before the legislature is to show that there's a flaw in the law, in my opinion, that comes out of this legislature that allows our state and our government to withhold evidence from the public, from a person who's a part of the call. So as the committee looks at rules to perhaps reevaluate or additional legislation to provide in the future, I didn't want to miss the opportunity to bring out that very important case, because this occurred when my son was 4.5 years old. He's going to turn 11 in May.
When you come back, it would be helpful to us if you have the RSA number in your hand for us. It would be helpful if we know the specific dates and time, roughly time of the call, and which judges turned down your request. It would be helpful in, was there a criminal case or only a civil?
Yes, it's very
There was a
important.
criminal case.
I do
Okay.
want to show that I was found not guilty by a jury of my peers who threw out all the charges against me,
Mm-hmm.
and I still have not been able to have unsupervised visitation with my child.
Was there in the discovery phase of your criminal trial, are you saying it during discovery, all they got was 6 minutes and change
Correct.
of the tape? Even with your attorney asking for more?
Yes, this
Okay.
went right before. and
Okay,
this-
I'm going to
these are
stop now
problems
because
in
it's
that.
starting to move into retrying your case, which is a valid thing to do, but not for this committee's purposes. So when you come back, if you would have chapter and verse as much as you could, how many times a judge was asked to release more of the 911 call, when, who, where, and so on. That's the kind of specifics we need as we start to look at what changes need to be made. So I'll let you go now, but you made a great start, and I will, sure. Yes, the vice chair, please.
Thank you very much. The point that you raise is an interesting point because it does show the difference between the legislative branch and the judicial branch. In the Judiciary Committee, which actually meets in the same room, so I feel at home here. We have had a number of bills relating to what can and cannot be released by 911. I'm not sure that Children and Family Law has had any of those. So this is an issue that we're familiar with. But if I could just ask, is it not true that you're talking about more than one case, one that would have been in criminal court and then one that would have been in family court? Is that true?
Correct. And in my particular instance, Representative, the case was divided because the DV charges against me in the family court civilly have their own docket number. They had their own hearing. The family court had a different docket number, different proceedings. There were criminal charges made against me. Some went in the district court and also before the Superior Court, with appeals that went in both from the family part of my case before the Supreme Court as well as the DV part of the case. And this is an instrumental piece of evidence that I'm still looking for now, 6 years later.
I realize how, if I could,
Sure, please.
I realize how painful this is for you and how complex it is, but I would just remind you that this committee is looking exclusively at the family division of the circuit court. Nothing here. We have no authority and no reason to be looking at any actions in other courts, including, of course, the criminal courts in district and
Yes, I understand that.
And
The
so I just
important-
want to remind you of that for when you will look forward to hearing from you when you come back.
Yes, thank you for that, because when this is ultimately provided for me, my understanding of the rules of evidence is that this will be information not available to me at the time of my hearings and will be instrumental in asking for a new trial. So that's why this is so important for me to somehow get attention to this matter, to provide this important evidence so that I can try to resurrect a relationship with my son.
Thank you, Mr. Nugent. Anyone else in the committee? Just curious, was the evidence that was admitted in the criminal case, was that allowed to come into your civil trial?
It was not allowed to come in to the civil trial. And that's part of the due process area that this committee is trying to take a look at, where there were due process violations. And in my opinion, these happened because there is no check and balance. And my concern is for many other parents who
Okay.
face this. I did really.
Okay, I'm going to cut you off there. That was a specific question. I wanted to know that if evidence was admissible in the criminal case, to what degree was that not allowed into your civil case? And don't answer the question now, but answer it when you come back, please. Okay, thank you. And thank you for your testimony. Well, I don't see anything else before us unless anybody on the committee has something you'd like to weigh in on. Good. All right, this concludes our organizational day, and we will meet again 9:30 next Tuesday. And that's,
Do you know who's going to be invited?
could I ask the committee researcher, whom do we have scheduled in terms of stakeholder groups next week? I'm sorry. DCYF? Anyone else? Okay.
Can we expect, are we going to noon or could we be going to 2 or?
We're going to noon.
Okay, we're going to be going to noon. Okay, thank you.
Yeah. Yeah, so we can plan, you know?
Good, because we all have other committees.
Well, yeah. Thank you all. Yes. Could you come up to an old man's ears, please?